You're charged with two cases. You're charged with evading arrest and resisting arrest. You're facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description on the call slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid detainment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer. The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes before he was detained.
You can feel the judge's disappointment. He gave him trust and a chance, and then he tested positive again. It's more than defiance. It's a heartbreaking example of a missed opportunity. How many others sit in that same chair, promising change, only to fall back into the same pattern?
What was he doing wrong? All you said he matched a call slip. So
Yes, for a criminal mischief in progress, Your Honor.
that's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Then none of that? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really? I haven't heard anything. I'm going to find no probable cause. Mr. Gonzalez, be careful, man.
Okay.
When you get into a pissing match with people who have the power of arrest, who's going to win?
I'm not gonna be more careful. I promise. It's not gonna happen no more. I promise. I got my family. I wanna,
Okay?
Thank you.
Got it.
God bless you.
Dude. All right. Good morning, Mr. Walker. So, with us, you were charged with failure to identify oneself. That's why you're charged here with us, failure to ID, right? You're facing up to 6 months in jail and or a $2,000 fine. The reason that we're taking you into custody now is because you have 2 felony warrants for, it looks like you were on probation for a felony theft, and they filed, I guess, a motion to revoke because of that warrants issued. So that's why we have you in custody now. I can't let you go because then I would get in trouble. We're going to do probable cause in our case. You have the right to remain silent. Anything you say can or will be used against you. Well, I don't want to talk about the case. You've got a lawyer. You know, you need to talk to him, let him talk to me, because I don't want you to say something that hurts you anymore.
Yeah,
So let's just do probable cause, because I don't know why. I don't even know why we're here.
yeah, my son, I'm a single father. He can shame everything. There's no way to put on GPS. Like,
Hold on, let's do probable cause first,
I
because
know. Okay. GPS.
It's not up to him. We're just talking about these things.
I can't, there's nothing I can do on the felony case, man. I'm just a lowly misdemeanor.
In his defense, Judge, the felony motion is based on technicals, and in this new case, this failure to ID.
Really?
Yeah, I don't see any.
Well, let's do it real quick, and then we can talk, and I can give you more info.
On March 21st, 2025, officers were dispatched to a family disturbance call for service at 2525 Holsworth Road in Spring, Harris County, Texas, which is an apartment complex. The officer began by identifying the defendant, who could not provide a valid driver's license. The defendant verbally identified himself as Adam Mitchell with the date of birth of December 23rd, 1987. The reportee then gave the officers his correct name, and the defendant then admitted to providing false information due to advising about a traffic warrant that he believed he had. The defendant then gave his correct name. The officers discovered an active warrant for the defendant out of Cook County, though there was no extradition.
So there was a warrant out of Cook County.
There was, but there was no
Cook
extradition.
County, Illinois?
Yeah, sure. I looked at the NCIC, all I saw in there that it could possibly be was some sort of like traffic offense.
Okay.
That's Officer Shaker he's talking about. Don't say.
Not, right. So he gives the name of Adam,
Mitchell. And Judge, this isn't filed as a fugitive, just a straight failure to ID.
right. Well, because he wasn't. Well, maybe he was. I don't know. Regardless, so Mr. Walker, I'm going to find that there's sufficient probable cause. Well, hold on. I'm going to find that there's sufficient probable cause to go forward in this failure to ID case. It looks like,
Call the police.
I the one who called the police. They never asked me my name.
I don't,
Like, I'm the person who called the police.
was this, I thought it was a stop.
No, they
No.
were dispatched to a family disturbance at an apartment complex. The officer arrives, proceeds to try to identify both individuals.
Well, here's the turning point. The judge finally loses patience not just with the law, but with the fatigue of dealing with repeat offenders. You can sense his frustration. This moment highlights that justice isn't only about punishment. It's about breaking cycles before they ruin another life. The judge stresses that the individual has repeatedly returned to jail and that it's time to address the root cause of the problem. He emphasizes the need for honesty during evaluations, warning that if the truth isn't reflected in the report, the cycle will continue. The message is clear, enough is enough, and it's time to find a real solution rather than repeating the same mistakes.
Began by identifying the defendant, who could not provide a valid driver's license. The defendant then identified himself verbally as Adam Mitchell with the date of birth of December 23rd, 1987.
I mean, I get that you call the police, but nevertheless, I mean, we've got,
Then he told them the right info.
but you still gave the wrong info and then they looked them up and then they get, you know? So, I mean, there's enough probable cause to go forward.
Why would that didn't happen, but why did, like, if I call the police, why are they asking for my ID in the first place? They don't have the right to do that, sir.
They're going there for a disturbance.
Yeah,
They
because
have to, look, I can't get into that, all that stuff now. But they're going to investigate something that happened. There's a disturbance. They go there. Normally what officers do is they have to look at everybody who's there to determine, hey, who is this? What's going on here? Does this person have any kind of issues? And so, you know, regardless, the good news is that it looks like on your motion to revoke, the only thing is fees that I see in this case, okay? I can't let you go at this time because this is a felony warrant. You're set at no bond now, but you'll get to felony court on Monday, and at that point, I mean, I'm sure that they'll do something. I'm not gonna, you know,
That's crazy, man. I called the police.
I'm not gonna,
A couple fighting, and I just called the police. That's all I did, sir. I seen two couples fighting, and I called the police because there was a guy hitting a woman.
I can't give you legal advice.
She's writing everything down too that you're saying. Maybe later
Just
down the
don't
road,
say
you might
anything at
want to
this
say
point.
something
You
different.
can talk to Mr. Pons. I'm not putting any conditions on your bond. Just be careful, Mr. Walker. Okay, thanks.
What was our bond on this one? It's PR bond, right?
Yeah, he's got a PR.
No, I bought that for $1,000.
So you're.
That's right.
Yeah.
It's 1,000.
Excuse me, Your Honor, I'm approaching on Neil White.
Is he?
And Judge, he's been carried like since Monday, the 24th. That's when he appeared on your docket initially for a new charge for the bond violation report, which is filed, and also a motion to revoke and raise. But he was still incarcerated on Monday, Judge, Monday morning.
He's right here now, right?
He's here now.
Okay.
But
Come on, Mr. White.
Mr. White.
We were on bond for an assault of a family member.
Yes, sir.
Since 2023.
Yes, sir.
In 2025, in February, you pick up a terroristic threat.
Yes, sir.
And now you've picked up another assault of a family member and a violation for protective orders. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes.
So the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 16th, 2025, in Harris County, Texas, officer was dispatched to an apartment for a family assault.
Officer met with the complaining witness. The complaining witness had visible injuries on her face, including bruising on her eye and swelling on her head. The complaining witness went over to the defendant's house. Defendant grabbed the complaining witness by the arms and threw her into a table and chairs. Defendant began to punch the complaining witness multiple times in the stomach and slap her in the face. Complaining witness attempted to leave, but the defendant followed her through the apartment complex. The defendant currently has a protective order for terrorist threat, which bars contact between the complainant and the defendant.
Is that the violation of the protective order?
Yeah, it's a felony, VPO.
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. Actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out the videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the responding deputies. If he had punched her in the abdomen, Your Honor, I can really say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, it appears, but she refused transport to the hospital. I couldn't tell from the body worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises and it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not go. He did not violate the protective order. And
The violation of protective order is a felony offense anyways, so.
yes, Judge. Yes, Judge. I understand.